windows down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a girl.
Hello, everybody. Hi, Sherry. Paul's here. Hi, Courtney. I heard that you got stung by a wasp. 2 of them? Terrible. Terrible, terrible, terrible news. I haven't been stung in a long time. I'm trying to recall. I've been bit by, like, wasps before, but anyways, I hope everybody's doing well. We are going for a earlier show tonight. We're gonna get with some Braunlich. We have a couple different hearings. Hi, Casey Carey. We have a couple different hearings to watch. Bunches of them, if you will. But thank you for being here. I'm so glad to see you. Tell me what you had for dinner. If you didn't like what you had for dinner, tell me what you wish you had for dinner. Hi, American Courts. Wow, you have a check mark. That's pretty cool. Welcome. Yeah. Hope everybody is well. And tell me what you had for dinner. If you didn't like what you had for dinner, tell me what you wish you had for dinner. And make sure to clock in for your shift. Hit the like button. That's sort of mandatory around here. I mean, you can hit the dislike button. It's fine. It's fine. It's up to you. Oh, look at all these things going by. Okay, barbecue pork roast, still cooking. Hey, Jinx. Vegetarian chicken nuggets. And mashed potatoes for Casey Carey. That sounds pretty good. I mean, take out the vegetarian. Maybe just vegetarian nuggets? I am confused on the chicken part. But, you know, I do understand, actually. Yeah. I haven't eaten yet. As most of you know, I'm over on the West Coast. It's only 4 o'clock. It's not even 4:20 yet. That's coming up soon. I'm excited for that. Hi, Mac. How are you? We're getting ready for 4:20, and we're going to watch some court in the meantime. Over to see Judge Braunlich. Give me 1 second while I pull the one up. The one from the thumbnail, I was like, have we watched this yet? And then I saw, I did a little scrub through, and I saw the lady, you'll see in a second. And I thought, no, we haven't seen this, because I think I would have mentioned this beforehand. So, without further ado, you haven't eaten yet either, each and everything. I understand. That's very normal. Anyways. Oh yeah, how do I get back there? I get back there like this. Her art piece is what I'm talking about, ladies and gentlemen. Her art piece. Yeah. Hi, Heidi. How was the lake today? Always think of you in the lake. Beverly's here. Hi, Beverly. Teresa! Hello, sweetie. You guys, I love it. Love to see you here. Anyways, look at her art piece over here. It is, it appears to be on an easel. Easel? Why can't I say that word? Hi, Mark. I don't know why I can't say easel. I think I did say it. It just felt wrong. Sometimes things are like that. Anyways, it appears to be on an easel in her Zoom area. We've talked about this before, putting your Zoom background, making it appropriate for court, but let's see what happens. I haven't watched this hearing, so let's watch it together, shall we? Oh, she's going to show it off a little bit more for us. See, I wouldn't think that was her art piece except for the fact that it's in the middle of the room. Oh, she's crying. Ma'am, we haven't even started yet. Who are you talking to? It's like the world dying back there behind her. My God.
Calling matter of Blake Herman versus Joshua McDonald.
Record, this matter is before the court for the purpose of reviewing an ex parte order entered by this court suspending plaintiff mother's parenting time. That ex parte order was entered on June 17, 2024.
Oh my God. Therese, sweet tea, gifting. You're so sweet. Thank you so much. That is so awesome. We do members only every Sunday. People ask me when I stream every day and twice on Sundays because I'm crazy. That's amazing. We love it. We have such fun when YouTube Daddy doesn't shut me down. He does that sometimes. Like a true daddy would, I guess. Anyways, I thank you so much, sweet tea. That is so sweet of you. And Dawn Moore, look at that. I love it when I see names that we see for a lot. Yeah, I know, American Courts. It is. Ah! Look at that, Mac. There's gonna be 5 of them. Mamma mia! Cass, Kim, Brian and Kimmy. Charlene. Yay! For a second, I thought it was Charlotte. If you know, you know. That's from yesterday. Anyways. Yeah, it is a lot of lives, but I really love it. We're a bit of a family around here, American Courts. I'm not so good at making the videos as much. I know I should. That's what YouTube Daddy likes, but I prefer to hang out.
On account of an alleged assault of the 14-year-old child by the plaintiff mother. This hearing is being conducted via Zoom.
Thank you, Mac, by the way.
Present is Attorney Leah Worker representing defendant father Joshua McDonald. Mr. McDonald is present, and plaintiff mother Blythe Herman is also present. The court notes that actually when we were last year, it was July 2nd. And the ex parte order was continued, but mother was granted phone contact with minor child on Sundays, Wednesdays, and Fridays. And I was adjourned to today's date to determine the status of a CPS investigation. The parties have conferred this morning with the assistance of Ms. LaPrade. The recommendation of Ms. LaPrade is as follows. The mother shall have phone calls with minor child Elizabeth on Wednesdays, Fridays, and Sundays at 7 p.m. It's noted that the child is attending counseling. The party shall follow all reasonable recommendations of that counselor. And the minor child shall continue in counseling. It's further recommended that father be permitted to take the child to Florida from August 14th to August 18th. And the parties will appear back for its court to review parenting time September 4th at 9:30 a.m. That is the recommendation, Ms. Work. Is this recommendation agreeable with your client this morning?
It is, Your Honor.
Ms. Herman, do you understand the recommendation?
I do.
Okay, the court wants nothing more than to reestablish a relationship with you and your daughter. No question, teenagers can be challenging. Do you understand do you have any objection to the court adopting this recommendation?
I would like more availability as far as maybe what the mediator had asked if we could do dinners. I actually reached out to Josh and invited him and his girlfriend to a lunch date with Elizabeth. I'm trying my absolute hardest to co-parent from a distance, and I haven't seen my kid in 11 weeks.
Oh, that's unfortunate and sad for her. But I have to say, normally I am, how do I put this? Obviously and selfishly trying to position it so that people are like, well, you don't look like you could have a teenager. But bitch, that girl doesn't look like much more than a teenager herself. And she's got a teenager. Like, I'm assuming we're close-ish in age, but she literally looks like a 13-year-old with her art project behind her. Very confusing to me. Even her demeanor is quite youthful, allegedly, in my opinion.
Okay.
I'm
Well,
heartbroken.
it's not an unreasonable request, Ms. Rourke. What about a daughter having dinner with mom? Dad could drop her off. Mom can, whether it's, she could suggest a restaurant that maybe that Elizabeth likes. Dad could drop her off for a 1 hour meal with her mom in a public place. Any objection to that prospect?
Yes, Your Honor, at this point, there is, my client, Elizabeth, has started counseling. She's only been able to have one session so far, but she is just establishing a relationship with the counselor. This was a traumatic event. There's no dispute as to whether or not mom slapped Elizabeth. By Elizabeth's account, it was hard enough that she knocked her off the bed. Elizabeth is 14, almost 15 years old. She reported to dad that she liked the counselor and is, eager to continue seeing.
Ooh, okay, interesting. I mean, now I am uniquely positioned to take a position on this. Never even come close to slapping my daughter. No, seriously. And I can't think of a situation. And that's because my daughter, unlike me, is a good child. I was a terrible child. I should have been slapped many times. And I put myself in that situation. But it concerns me when a parent can't control their anger, especially to a teenager. So, but is CPS involved? Is there a reunification plan? You can't just have, forever barred after one incident. Although I did watch a termination trial today. But anyways, that's besides the point. Also, do we think the art is symbolic now? Is that a piece of the child's art? Is that art done from her heart? I don't know. What do you think? What do you guys think? I wish I was Mikey and I could do art like him and do a recreation.
Her. But following this event in May, Ms. Herman attempted to essentially gaslight Elizabeth into, all of the reasons why it happened and trying to minimize it. This was traumatic for Elizabeth, and we think that she would benefit from some additional counseling and the support of her counselor in having conversations with mom to address this rift in their relationship. And we think that Elizabeth needs that support in order to be able to do that in a healthy way. There's a power differential here between a parent and a child. And so.
And the court understands all that, Ms. Rourke, understands that. And obviously 14-year-olds can be challenging. I've raised teenagers.
Certainly, Your
The
Honor.
question is, would, if Mr. McDonald, if Elizabeth if mom wanted to meet her for dinner, would Elizabeth refuse to attend?
Yeah, right now, yes.
All right. Well, we don't want to force things, Ms. Herman. If in fact, Elizabeth, we don't want to force things. Do you know who the counselor is, Ms. Herman?
Yes.
Talk with the counselor.
Okay.
Talk with the counselor just so you get insight in terms of what you can do in terms of reestablish relationship with your daughter. And again, sometimes you need to, and I don't want to put this off. That's where we're getting a review date. The court wants to develop and reestablish and repair this relationship. We've got to do so in a deliberate, careful fashion. And hopefully when we come back, that at least we can maybe have some meals. I mean, talk with the counselor. If she thinks that Elizabeth, now saying what Mr.
Oh, I'm hungry too, Judge. I'm hungry too. If you're just getting here, thanks for coming. Please tell me what you have for dinner or what you wish you have for dinner. I literally use all of your guys' items to decide on my dinner later.
McDonald, if she thinks that Elizabeth would be willing to meet you at a restaurant in public for dinner, And there's no reason why we can't talk about that when we come back. But if in fact Dad's saying Elizabeth wouldn't do that, we don't want to force things and create any further problems. What do you think Elizabeth would go? Meet you at
I've
the
asked
restaurant?
her, I've asked her a few times and she tells me no every time. So I don't want.
Yay, Wendy! Thank you so much. Another member. Love it. Love it. Can't get enough of it. Ooh, cheeseburger, no bun, and curly fries. Jinx. All right. All right. Heidi's having Chinese. We all know I love Chinese food. I'll take pasta. Oh, you craving thin crust pepperoni pizza? Whew. Now I'm really hungry. Damn it. And also bacon pancakes sound really good too.
Want to push the issue on her,
All right.
if that makes sense.
All right, so the court's not going to force it at this time, Ms. Herman. Mr. McDonald, obviously encourage it. I mean, you need to, the best thing you do for your daughter is to tell her that her mom, she got one mom in this world, her mom loves her, and that they just need to work out some of their differences. That's all, and encourage that. Keep an open mind. All right, anything further than this morning, Ms. Herman?
No, Your Honor.
Okay, we'll review this on September 4th at 9:30. It's only a month away, and hopefully we can have some personal contact at that time, but do communicate with the counselor.
Yes, Your Honor.
All right, anything further, Ms. Werka?
No, Your Honor, thank you.
All right, go adopt the recommendation, and we'll review this matter on September 4th, 9:30 via Zoom. All right, that will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
We'll
Thank
be
you, Your Honor.
there, Judge.
Thank you. You too.
September 4th. We will be there. Let me get the next one ready to go. We're into Judge Braunlich's. Why are they X'd beside them? Availability status. Error. It says error. That guy's head looks really flat, doesn't it?
Okay.
Calling matter of Mark Eastman versus Rotenberg. Oh, I apologize. Calling matter of Mark Eastman.
For the record, this matter is before the court for a pre-trial conference, in addition to the plaintiff's motion for mutual restraining order, as well as temporary exclusive use of the marital home on Plank Street. This hearing is being conducted via Zoom due to the fact that Mr. Jenick filed a motion and noticed his motion for hearing via Zoom. Present is Attorney Steve Jenick, representing the plaintiff, Mark Eastman. Mr. Eastman appears to be present with Mr. Jenick. Also, Attorney Stephen Rotenberg is present. Is Michelle Eastman, is she present, Mr. Rotenberg?
No, she is not, and I sort of take the blame for that. The original notice for the motion, I was aware of the pretrial, but the original notice for the hearing went into my spam folder. So I didn't know about this until Mr. Jedniak called me up and said you were looking for me and wondering where I was. And Ms. Eastman cannot attend because A, she didn't know about this till I called her. I did speak to her ultimately. And B, she works for Lake Erie Transit and she'd probably lose her job if she zoomed in on this hearing. And I apologize for that.
Okay, she could take time off. We're not suggesting that she zoom in from the fucking bus. Sir, also fix your collar. Please. Ay vey.
All right, Mr. Rotenberg, the notice, the proof of service filed, Mr. Jenick indicates copy of the motion notice hearing and was mailed to you. So
It was mailed. I did a
spam
Scrivener's
folder.
error. And if you take a look, some of the stuff says my old office address on Telegraph Road. And some of it says the new address on Northwestern Highway. Again, Scrivener's error. I'm my own typist. I screwed up.
Okay.
Okay, I own this, at
Okay.
least for those parts of it.
All right, we'll get through this. This is a 6-year marriage,
Mhm.
no children. What are the issues? I'll start with you, Mr. Jednick. We obviously have real property and personal property division. Is that correct?
Personal property, real property might be the biggest contest here. Mr. Eastman would claim it as a premarital asset. The wife's going to claim equity in the home. I think the resolution is going to be somewhere in the middle. He's the owner and he pays the mortgage and all the bills. The parties don't have any pensions. There's no minor children. I know there might be a claim for spousal support from wife. She works at Lake Erie Transit. My client's on medical retirement and Social Security. It's a 6-year marriage. So the wife may make that an issue. There's no joint accounts left. The parties have minimal money in separate bank accounts at this point. They each have a vehicle. There's some personal property. We don't think there's that much debt, although I think there's a allegation from wife that Mr. Eastman's opening a bunch of credit cards and ringing them up, which is not true. But he only identifies one credit card having about $3,000 of debt. So it's a fairly modest marital estate.
Okay, thank you. And obviously, with respect to the real estate, even though Mr. Eastman made the mortgage payments, obviously, arguably, the defendant, Michelle, is entitled to half of the increased value over the period of the 6-year marriage.
There's also an old.
We need to get look at some SEVs. Court suggests SEVs from the date of marriage to current, as opposed to having to expend the money for an appraisal, historical appraisal and a current appraisal. That can get expensive. So the court's suggesting the parties look at SEVs, try to find some middle ground.
There's also an old claim, Judge.
Hold on, I'm sorry. Let me just finish, Mr. Rosenberg.
Okay.
That's what the court's suggesting. In the debt, there's about just one credit card. Is that correct?
Now he identifies, yes. I don't know if she has other accounts.
Not sure, Judge. I don't have my thing in front of me, but there are some debts. So their debts are an issue. I don't think they're huge, but we haven't quite determined what they were. Again, I just figured out this morning that Mr. Jedniak sent the financials actually before I sent them to him. So, he did. I have not had a chance to review them. I just know that I've got them.
I'm just noting for the court's information, there's an issue of unsecured debt, personal property division as well as real property division. I don't see without further information, I don't see this being a spousal support case. But in any event, that's just for the court's information. How much the two of you talked with Ms. Patrick this morning? She's indicated the two of you are available to mediate on September 16th at 1:30. Will discovery have been completed by then? I don't want to waste everyone's time. I don't want to waste a valuable mediation slot.
What do you think, Steve?
I think a market appraisal might be what we need at this point. I've looked at his financial verification forms. Hopefully he has mine. So I don't think there's a lot for accounts we need to exchange, unless you're saying we're hiding something. But a market so for mediation is what we probably need.
Yeah, but I think the SEV. May I interject? The SEV, we can probably figure out what the multiplier is for an actual value, what the discount or premium is for the location. Because I know 2 times whatever works for that, but we can also back it out and figure it out with price sales and say, oh, it's really 2.3 or 1.8 or whatever. That might be a way to
work through. Sounds like two of you can work through that together in terms of without having to incur the expense of a formal appraisal. A fair market current, I think a fair market analysis, maybe by a realtor would help, or look at SEVs, compare the SEVs today and back when the parties got married 6 years ago. So this works with both your schedule, and will be a Zoom mediation with Ms. Patrick. Ms. Patrick, can you kindly reference your Zoom ID number on this recommendation?
Yes, Your Honor, but I did verbally give it to both parties, but yes.
Oh, okay, all right, that's fine. Ms. Patrick has also recommended that the court enter order this morning, enter a mutual restraining order conserving property. That appears to be appropriate. And further that the defendant, Michelle, vacate the home at 737 Plank Road in Dundee on August 30th. Mr. Rosenberg, did you discuss that recommendation with your client this morning?
I I did very briefly, hang on, Judge, there's a little background noise. I have a machine just shutting itself down behind me. Okay, here's the issue that we have. Number one, I didn't know about this. And generally, landlord-tenant issues and evictions are governed by a different set of laws rather than family law. And as Mr. Jedniak stated, and I would have brought up, Ms. Eastman has an adult daughter whose name escapes me who lives there. She's not subject to the jurisdiction of this court. She's a third party. The court doesn't have, so they don't have, there's no personal jurisdiction over her. And there's no subject matter jurisdiction over her because she does have a tenancy. She's been living there for a while. So they'd have to give her a 30-day notice to quit and do the whole rigmarole through the district court to remove her. So even
if this court's not concerned, Ms. Brownberg, hold on. This court's not concerned about a third party. So if there's some other
right, but
person
if
living there,
she's
that's between. Hold on, Mr. Rosenberg, please.
Okay.
I could care less about a third party. And this is the first time I've heard about a third party. Mr. Jedniak, you need to take other action to evict that person. We're only talking about these parties, Mark and Michelle. So the question, Mr. Rosenberg, is Michelle, does she oppose this recommendation that she vacate on August 30th?
Yes, she does. She'd like a little bit more time. We're asking for about 45 to 60 days so she can find a new place to live because otherwise she'll be homeless.
Okay, well, well, obviously you put the court in a difficult situation because
You put the court in a difficult situation because I'm a cranky old man. Hi, music. Judge is he's going through the change, allegedly. You know, he's just hot flashes, anger flashes. What I will say is that's true. You can't evict somebody else. I just love that he said subject matter jurisdiction and it wasn't a soft sit. That's great. Also, it's just a weird situation. A weird situation so far. But judges, he's always quite cranky, you know? Just extra cranky today. Extra cranky. I don't know why, Judge. We're having a wonderful day so far. You can hear the birds probably outside. Just fucking cawing. Caw, caw.
that's a recommendation to Ms. Patrick that she vacate at the end of the month, but your client's not here.
I know because she didn't know about this because it went
Hold
because
on, Mr. Jetnick, Mr. Roberg, you were mailed a notice. You said it's on you, so it's not your client's fault. You acknowledge you take responsibility
Yes.
for not checking your mail.
No, it went to my spam folder, Judge. As for the mail, it went to the wrong address because of a Scrivener's error by me. But the practical matter is yes, you can say to Ms. Eastman, move, but there's still maybe a third party there who's not my client.
I could care less about a third party. I don't want to hear about a third party. I have no jurisdiction over a third party. I agree, Mr. Owenberg, so I could care less who that party is. This court has no authority over a third party that might be residing in the home. But the court, Mr. Jednick, is reluctant to order that she vacate without her being here and participating.
Then I want a very brief adjournment, Your Honor, so we can address this. And Mr. Eastman's been pretty patient regarding this.
And I'd be fine with doing this as quickly as we can.
Okay, the court will adjourn to 9:15 tomorrow morning. Are you both available?
Yeah, I am.
We could be here.
Okay, I'm
By
going to
Zoom?
hold this order. I'm going to have the parties. I don't know if Ms. Patrick's available again tomorrow, but let's get her here. I want her to participate, and we'll continue. So 9:15 tomorrow
Okay.
via Zoom.
Okay, Judge.
I'm not going to mail out notice. We don't have time, but just everyone appear via Zoom at 9:15 tomorrow morning.
Okay.
All right, you can zoom out. That will conclude this pretrial conference. We'll continue
Thank
tomorrow
you.
at 9:15 and the motion hearing.
Get the fuck out, he said. Get the fuck out. Wow, Judge. Let's just continue on down the line of Judge Braunlich.
It's a phone.
A laptop or something that he can participate?
Oh, for
He's
God's sakes. Do you know, did you see my heart jump into my throat there? I was like, that sounded a bit like me. Did I record a phone call? I literally had a moment there where I thought I like recorded this, but I didn't record this. I don't think. Anyways, let's just let them talk, Paisley.
Literally right here. He can hear you.
Okay, perhaps put your phone on speaker.
Okay.
We'll call the
It
case.
is. Yep. It's on speaker.
Okay, all right, we'll call the case.
Calling the matter of Shelby Wilson versus Bradley Wilson.
For the record, this matter is before the court for a continued pretrial conference. Same is being conducted via Zoom. Court is in receipt of a proposed default judgment of divorce. Is Shelby Ray Wilson present on audio?
I am.
Okay, Miss Wilson, is your husband Bradley, is he present in the same room with you in the same home?
He is. Yes.
Right. Mr. Wilson, can you
Can you
acknowledge
say
that you are
something?
present?
I'm present.
Okay, Mr. Wilson, have you reviewed this proposed default judgment of divorce?
No, I have not.
Okay, we'll review it right now. Miss Wilson, you have a copy of it, correct?
I do. Yes. Yep.
Okay, and you signed it, you indicated that you served, you hand delivered to Mr. Wilson a copy of this judgment.
I did.
Oh, you did it.
Yes, I did. Yes, I did.
Well, hand it to him right now.
I did. He has it. It's right. I have it right in front of me. I can't even put it on video. Let me see. If I need to, let me find it real quick. I'm going to start the video. I'm a kind of a mess, but I know that's not relevant. Let me see if I can swap it around.
Right.
This is
Is that a towel?
the
Man,
letter, and then I turned in the original copy. It's hard to see, but I gave him a copy of the divorce order, and then I did serve him the letter that the meeting is today as well. The notice of hearing and the actual papers themselves that I signed.
All right, Mr. Bradley Wilson, do you have a copy of the proposed default judgment divorce in front of you?
He walked outside. He's not even in the room now. He walked outside. He's not willing to participate at all.
I'm sorry, can you repeat what you just said, Miss Wilson?
I'm so sorry. He's not willing to participate at all. He just walked outside and went out into the yard somewhere. He's refusing at every
Okay,
angle.
your husband Bradley, when you say he, your husband Bradley
Yes.
refused to look at the judgment, he just walked outside, is that correct?
Correct, Your Honor. Yes, he walked outside. He's not even in the same room at this point.
I have so many questions about what on earth is happening in this house. She's in a bath towel, or like has her hair wrapped in a towel, it sounds like, or it seems like. He doesn't seem very willing to participate in this divorce. I mean, you can get one without the other person really wanting one, but still a little weird that they're appearing together. Do they still live together? Has she not told him yet?
Okay, all right, Ms. Wilson, can you raise your right hand to be sworn, please?
Yes.
Do you solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, the record reflect that Mr. Wilson is present, but her husband Bradley was present, but has walked out of the house, refusing to engage in any conversation with this court regarding resolution of this marriage. The court notes it's a 5.5-year marriage. Parties are still residing together in the marital home. Proofs were previously taken. The court file, the record should reflect that Mr. Wilson failed to appear for a pretrial conference on July 11, 2024. The court accordingly entered a default at that time. In the interim, Ms. Wilson has prepared a default and submitted a default judgment of divorce. The court file reflects that Ms. Wilson noticed for hearing for today's date and time, entry of the opposed default judgment divorce. Court file also reflects that on July 17th, Ms. Wilson hand delivered to Mr. Wilson a copy of the notice of hearing and motion for entry of default judgment. As as well as the proposed default judgment. She again tried to give that to Mr. Wilson again today, but he refused to look at it and simply walked out of the house. Ms. Wilson, can you please state your name and current mailing address for the record?
Shelby Wilson, my address is Samaria, Michigan, 48177.
The judgment reflects a post office box 4, Samaria, Michigan. Will that mailing address also
Yes, Your
facilitate
Honor.
this
Yep.
judgment getting to you?
PO Box number 4. That is correct.
Samaria?
Yes.
Okay.
Yep. 13446. PO Box 4.
All right, to Ms. Wilson, we previously took testimony from you back on July 11th. Court established jurisdiction. There's been a breakdown. There's no minor children. Are you currently pregnant?
I am not, Your Honor.
Right. The proposed default judgment finds that spousal support is not awarded and
No.
forever barred to both parties.
Not necessary. Yeah. Correct.
I'm sorry?
Yes, correct, Your Honor. That spousal support is not necessary. That is correct.
Okay, you've attached to this judgment a proposed real property addendum. The two of you own the home on North Street in Samaria. This addendum provides that the home is awarded to both of you, but it shall be sold within a reasonable time.
Correct, Your Honor. Yep, that is the case. Yes.
Are equal in any profit or loss relative to the sale of the home. So when this, you can then go ahead and list this. If he will not cooperate, you may need to take him back to court, get him to sign the listing agreement.
Okay.
Get that home on the market as soon as possible. Hopefully you can agree upon a realtor. So that appears to be reasonable. Personal property is divided according to attached personal property and debt addendum. You have attached a personal property and debt addendum. Does not address personal property.
Yeah, it's only, there's,
debt.
yeah, exactly. Yep, it's only loans and credit cards. He requested that those be split, and I'm willing to do so.
What are you gonna do with household furnishings and effects? Who's gonna get the lawnmower? Who's gonna get the table, kitchen table, things of that nature?
We have agreed to what has, because a lot of it has been through family. So per party, what family has gifted is what we're going to go about dividing.
So I can put in
we
the
have
language, I can put in here that it's gonna be as agreed.
Yes, yes, Your Honor.
Okay.
Yep, we are on agreeable terms when it comes to that.
Okay, I'll just write the words as agreed in terms of personal property, and I'll put my initials next to that so we don't have any blanks in this judgment.
Yes, when it comes to pots and pans and couches, we will absolutely figure that out between each of us agreed.
Good. Okay, each will keep their own automobile and their name, pay any debt they're on. Each will keep their own retirement benefits. With respect to that addendum. I'm sorry, Ms. Wilson. We can't both talk at the same time. Go ahead.
I'm so sorry. That is no. I apologize. Yes, no. That is correct. Yep.
Okay, I'm just trying to create a record in terms of what's set forth as proposed judgment. You have addressed that addendum, that plaintiff, which is yourself, shall be responsible for American Express. You seem to have the same debts on both for plaintiff and defendant. So what are you going to share equally all those debts? American Express.
Correct.
Okay, so obviously what you do is probably the best way to do is once the home is sold, pay it off the top of the proceeds.
Okay.
From the net proceeds to sell the home, and then you get the credit card debt all paid, then whatever is remaining you can divide equal. That's probably the easiest way to pay off this debt. It's joint debts, and you've agreed that each will pay equally the American Express card, the Lending Club debt, the Capital One, the Monroe County Community Credit Union debt. That takes care of the joint debts. You're asking for restoration for name of Bartel. When you copy his judgment, you need to take copies to Secretary of State and Social Security to facilitate the legal change of her last name. So everything appears to be in order. Ms. Wilson, do you have any remaining questions for the court?
No, nope, I do not. I just want everything to remain fair, like we just discussed with the splitting of the debts and the selling of the house, changing my last name, and that's it, Your Honor.
Okay, it all appears to be reasonable. The court notes it's 5.5 year marriage. It's good you still are in the same roof, but obviously this judgment does provide that the home shall be sold.
Yeah, it will. Yeah, at within a reasonable time, it will. Yes, Your Honor. Yep.
Hopefully, Mr. Wilson, the terms are very reasonable.
I'm trying.
For both of you, hopefully he'll cooperate and he will sign a listing agreement. So you can move on that and agree upon a list price. Very well.
Yeah,
Do
precisely.
you have any other questions, Ms. Wilson?
Not at this time. I appreciate your time, but I don't have any questions at this time.
All right, based upon the testimony that's been presented today, as well as back on July 11th, as well as complaint files, the court finds again jurisdiction's been established. There's been a breakdown of the marriage relationship. There's no chance of reconciliation. Accordingly, it's ordered by this court that the marriage between the parties be and is thereby dissolved, and judgment shall enter granting a divorce from bonds matrimony. Copy of the judgment has been signed. A copy will be mailed to you, and a copy will also be mailed to your husband, Bradley, your former husband, Bradley. All right, good luck to you, Ms. Wilson. That will conclude this hearing. You can zoom out.
Bradley did not participate. Bradley got up and walked away. What I wouldn't have given to see that live. I really would have enjoyed that. I'm telling you right now, ladies and gentlemen, right now. All right, probably second last one.
Morning, Your Honor.
Good morning. What do we have here? Heidi's been a member
Okay.
for 2 months.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Is Miranda Trout present on audio?
Yes, I am.
Morning. And Nicholas Brown, defendant, is present. Good morning, both of you. You both conferred
Yes, Your Honor.
with Ms. Patrick, our friend of the court this morning. Is a custody complaint. 1-year-old child. The primary question for the court is any reason, Ms. Trout, why you, Mr. Brown, cannot share joint legal custody of the child. Joint legal custody means you share equally any major decision concerning the welfare of the child, such as elective surgery, things of that nature, important decisions regarding the welfare of the child. Can you agree upon joint legal custody? I mean, when we don't get bogged down on physical custody, it's just a matter of joint legal and then the parenting time. Ms. Trout, this court is addressed to you. Any reason why the two of you cannot, as parents of this child, share joint legal custody of the minor child?
No.
All right, court was so ordered then. Ms. Patrick, you can prepare an order that the parties shall have joint legal custody. Parenting time you cannot agree upon, is that correct?
I'm sorry, what was that?
You cannot agree upon parenting time, and Ms. Patrick, can you advise the court what you talk with the parties? What is it? What is the issue between the parties? Ms. Trout cannot seem to answer that question.
Your Honor, when discussion with the parties Mr. Brown does acknowledge that he's the father of the child. We did break down when it came to the custody. Mr. Brown is looking for joint legal, joint physical, and 50-50 split of time. And I believe Ms. Trout did not agree with that. She wanted sole physical custody of the child, and she wanted him to take the schedule that she had written out. He does not agree with that schedule.
Okay. Well, the court suggests, why don't we enter an order this morning that gives grants joint legal custody of the parties and refer the issue of parenting time to the front of the court for a formal investigation recommendation. Any thoughts on that,
We did talk
Ms.
about
Patrick?
that, Your Honor.
All right, Ms. Trout, Mr. Brown, do you understand what the court is inclined to do this morning? Enter an order this morning that the two of you have joint legal custody of the minor child, and we will refer to the front of the court the issue of parenting time for formal investigation recommendation.
Yes, Your Honor.
Yes.
Okay, Mr. Patrick, if you can prepare an order in that effect, at least we can stop the clock by entering a custody order. Mr. Brown, Ms. Trout, can you both please raise your right hand to be sworn, please? Do we both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Yes.
All right, Ms. Trout, can you please state your name and current mailing address for the record?
Miranda Trout, and my address.
Is that 48161?
Yes.
Okay, and Ms. Trout, you filed a complaint for custody, seeking custody and parent time order relative to the minor child, Lena Marie Brown, who's 1 year old. Is that correct?
Yes.
And do you admit and acknowledge that Mr. Brown's name is on the birth certificate of that child?
Yes.
Okay, so you agree Mr. Brown is in fact the biological father?
He's her baby daddy. Vince, thank you so much for joining back up in the crew. Also, how was the chiropractor? Do you feel so open? I was saying I pay for my hugs too. Sometimes when I used to go to the chiropractor and he used to do that like thing and I'd be like, oh, this is sadder than it really is, Paisley. Oh God.
Of that child, this being a custody complaint, so paternity is not really an issue.
Yes.
You acknowledge that it would be in the best interest of your daughter that Mr. Brown be able to participate in major decisions concerning the welfare of her daughter.
Yes.
Okay. Does Mr. Brown, do you allow parenting time with the child and Mr. Brown at this time?
Yes, she does.
Okay. So, Ms. Trout, what's been your practice, Ms. Trout? Do you have a set schedule that you've been practicing?
Yes.
Okay. All right, Ms. Trout, do you have any questions to the court?
No.
All right, Mr. Brown, can you please state your name and current address for the record?
Nicholas Brown, 31 New Boston, Michigan, 48164.
Thank you. Mr. Brown, you likewise agree. First of all, you do acknowledge and admit that you're the biological father of the minor child, Lena Marie Brown. Is that correct?
Yes, Your Honor.
And you believe it's in her best, the child's best interest that you and the mother, Ms. Trout, share joint legal custody?
Yes, Your Honor.
Okay. I will tell both of you, well, before I say anything, do you have any questions for the court, Mr. Brown?
No, Your Honor.
All right, the court this time will enter an order that the two of you share joint legal custody. The issue of parenting time is referred to the front of the court for a formal investigation recommendation. You'll both be contacted by the front of the court and send a questionnaire, and there'll be a phone interview. They'll make a recommendation. And hopefully with that recommendation, that may form a basis for you to reach your own agreement. I will tell you, you don't want the court raising your child. I mean, you as parents know what's better for your child than anyone in this world. You don't want a stranger deciding what's best for your child.
Yes.
So, and that child needs a mother and a father in her life. So please work together. Try to develop your own parenting time schedule. Obviously, the court would strongly recommend you continue what you've been doing, even though there's no order to that effect, and to see if you can tweak that to make it work. Anything further this morning, Ms. Patrick?
No, Your Honor.
Okay, if you could prepare such an
hope his name
order,
is
I
Tasty
would appreciate
Brown
that.
Trout.
And then once you get a recommendation, then one of them will have to renotice it before the court if they have an objection, correct?
That's correct, Your Honor.
Does the recommendation, does it provide for becoming an order of the court unless they file a written objection in 21 days, or it simply just stands out there?
It just stands out there until someone takes action on it, Your Honor.
All right. So you both understand you'll ultimately get a written report from the front of the court, their recommendation to this court. You'll both get a copy of that. And then if one of you wants to incorporate it into court order, one of you needs to bring it back before the court. We notice it for hearing.
Okay.
Right. Any questions, Ms. Trout?
Nope.
Okay. All right. The court encourages you to work together and develop a parenting time schedule where your daughter spends as much time with each parent as possible. All right. That will conclude this matter. The court will enter. You'll both be mailed a copy of this order. Thank you, Ms. Patrick.
You're welcome, Your Honor. The order is in your queue.
Thank you. We can stop the clock. We got a custody order this morning.
Stop the clock on the custody order. It's like the judge has KPIs that he has to worry about. My key performance indicators are going to go down if we leave this custody case on the block too long. Cut the clock. We have time on our clock for one more video before I will pass you along to the next entertainer for the evening. Give me 1 second. We'll pull it up here. We're sticking with Judge Grumpy. He is certainly grumpy today. I will tell one story quickly. Do recall he means it when he says you don't want him making decisions for your child. I'm pretty sure it was him who was asked to make a decision about a dog that the couple was fighting over custody, and his solution was to sell that dog. Can I pet that dog? Can you sell that dog? Basically is what he said, but not in the cool meme voice. Sell that dog. Seriously. I think those people probably went home and shit their pants together, maybe had a little makeup sex, and then separated the dog amicably. He was just so serious about it. He's like, we'll just sell that dog. And they're like, can you sell that dog? Oh, hello. Yes, yours is fine. The guy earlier, his was not good.
Matter of Christian Gaskill versus Elizabeth Gaskill.
For the record, this matter was before the court this morning for a pretrial conference. The same is being conducted via Zoom. Present is the plaintiff attorney, Andrew Babnick Jr. However, none of the parties are present. Mr. Babnick, you're 15 minutes late. You're 18 minutes late. This matter was scheduled for 8:30 this morning. And reviewing the file, I noticed you filed a notice of hearing that a consent order would be entered on September 3rd, 2024. You can take that off. You know, the court has no control of that. But this court entered an order that you and the parties appeared at 8:30 this morning via Zoom for a pretrial conference. So once you get your client here in the next 15 minutes, the court's going to dismiss this complaint.
Your Honor, I apologize to the court because I never received the order. I would have appeared.
Hold on. Is your address 2723 South State Street, Suite 150, Ann Arbor, Michigan?
It is, Your Honor.
Okay, it was not returned as being undeliverable. You need to check your mail.
I'm sorry, Your Honor. Again, I did. If I would have received the notice, I would have been here. I'm so sorry for the court's time. And opposing the other party is a improper. I will get her immediately. Her I can reach. She is local. I will call my client. My client is in military overseas, and I will try to get him immediately, Your Honor.
Okay. Again, I don't have a phone number for Ms. Gaskill, but likewise, her notice. I've got actually there's a phone number for her in her answer. Do you have her phone number?
I have her phone number, Your Honor. Yes, I do.
Okay. Why don't you call her, see if she can zoom in? We have people in the military zoom in from Europe all the time.
Understood, Your Honor.
Understand there'd be a time difference, and you say you never received your notice of his pretrial was mailed on July 10th.
No, Your Honor, again, I have absolutely nothing, and I apologize to this court. We would 100% been here. I thought after we set, the only thing I had was my notice of hearing after speaking with Chambers to coordinate the September 3rd date. So I apologize to this court. I in no way wanted to waste this court's time.
Obviously, your notice and our pretrial notice sort of obviously passed each other through the mail because we received your notice on July 15th and we mailed out our notice on July 10th.
And I apologize because I spoke with Chambers to coordinate the date on July 11th based on my notes. So I wasn't aware at the time, and I apologize, Your Honor. Again, I'm very sorry for the wasting this court's time. These parties were in agreement on this order, and this should have run smoothly. So I apologize.
Oh, his slick sorry voice wouldn't work with me. I'll just tell you that. He's hyping me up to the next level. Hi, Mikos. I don't know why, but judge came in there at 110. This guy is doing what all lawyers have to do. They have to just take the spanking. I mean, all subs have to do that in some way or another. But in reality, it's just hilarious to me because you can just tell. I have a fucking guarantee that he's gonna get off this call and be like, fuck him. Like, he's not gonna sit there and be like, oh wow, I really wasted that judge's time. God. Also, I don't know if he got the lady back on the phone or if he got them on the phone. I'll have to look through all my stuff. We don't have time for that tonight. tonight I'm redirecting all of you to Collins right after this. But yeah, the mail isn't 100%. I saw some mail that we just got, well, Canada's different, but it took like almost a month and it was in the same province. That's a long time. I thought that they would have, hey, roll. I thought that they would like send things like that by courier, you know? I don't know. Let's finish it off. Let's let the spanking continue.
Well, immediately I'm emailing my client as best I can. I cannot reach him by phone. He has no phone where he is, so I'm going to continue to try. I would ask if the court would be willing to simply give me a brief adjournment, and just in case. I don't want to see this dismissed with the parties in agreement, and if it's my office's fault for not receiving the communication and letting the parties know, that's on me. Because I would have,
first of all, the court's chambers have not set dates. That's the clerk's office. So we don't give out hearing dates. The clerk's office does. So in any event, I'll give you till 12 noon. I've got an evidentiary hearing. It's starting at 1:30 for the rest of the afternoon. So hopefully we'll see everyone back here before 12 noon this morning.
Your Honor, would you like us just to log back into the Zoom, or should I contact chambers first?
Yes, a phone call just to let me know that the parties are zooming in at a certain time. That would be appreciated. I have a pretrial conference every 30 minutes this morning, and I've got to have the evidentiary hearing at 1:30.
Okay.
So
Again,
hopefully we'll have everyone here before noon today.
Okay. I apologize again, Your Honor. Thank you for the courtesy.
All right, you're welcome.
Wow. Judge Cranky Pants at his best. Back to the kitchen. Thank you guys so much for being here. I know it's a bit of a shorter show tonight, but we have many, many shows. I was saying earlier, I go live every day and twice on Sundays. Another type of schedule I like to keep. But the point being that there's a lot of shows to watch. So if you go back and watch some, leave a comment so that I know you watched it. Leave me a timestamp of something funny to look at. I love those. They are my favorite. Anyways, I have set this up to redirect over to Colin. Make sure you mention my name. No, I'm just joking. I will give you the little last reminder. Shit don't go down the same over there as it does here. I know they're not speaking to us exactly, but every time I send us over there and they start with their PG-13 thing, I always feel a little bit like being bad, and I shouldn't, and neither should you. But remember, we can fuck shit up around here, but be a little more PG-13. Now we're there. Anyways, thank you so much for being here. American Courts, thanks for hanging out. Lovely to have you. And also, everybody that got memberships today, that's on Sunday. So, I will ask you to remember that I love you. I am proud of you, and I will see you in the next video. Bye.
Ways down and ready to ride.